Isabel Tommy, just before you get underway, I should say that this is the case where we will be taking brief breaks halfway through each session. So if you could look to find an appropriate point somewhere around 11:45. I suppose midpoint this afternoon, it probably won't still be you, or that may be the point at which you're sitting down. But were you still on your feet, could you look for a break somewhere around 3:15?
Lord, yes, thank you. Lord, I appeal Mr. Kennelly for the appellant, Mr. Chapman, Mr. Patel, Mr. Harmon for the claimant respondents. As you will see, it's an appeal from paragraph 9 of the order of Mr. Justice Michael Green, largely dismissing the defendant's strikeout application. And the appeal pursuant to permission concerns two aspects of that application, what we call the Brutus fraud allegations and the Maxpower bribery scheme. Could I begin by giving you 10 minutes by way of overview of the claim, because then we can then burrow into the issues as they arise. And starting with the cause of action, and can I ask you to turn to the bundle of authorities, tab 1, which has the relevant bits of the statute. The claims are under section 90 and section 90A of the Financial Services and Markets Act. Both are concerned with the provision of misleading or inaccurate information by issuers of public securities. Section 90A is on page 6 of the bundle and imposes liability on the issuers of securities to persons who have suffered loss as a result of misleading statements in published information, dishonest omission from published information, or dishonest delay in publishing information. The detail of the cause of action is set out in Schedule 10A on page 8. And very briefly on that, if you go to section 3 on page 10, you see that in section 3, paragraph 1, an issuer is liable to pay compensation to persons who acquires, holds, or disposes of securities in reliance on published information and who suffers loss as a result of an untrue statement, the omission of any matter required to be included. But only if, on subparagraph 2, a person discharging managerial responsibilities knew the statement to be untrue or was reckless about the truth of the statement. Or in paragraph 3, in respect of an omission, only if that person, known as a PDMR generally, acted dishonestly in relation to the concealment. You knew the omission to be a dishonest concealment. That's misleading statements, 3.1, omissions, 3.3, and if you then go to paragraph 5, section 5, that deals with delay in issuing relevant information, and the liability there at 5.2 is that the PDMR acted dishonestly in respect of the delay. In substance, this is a cause of action for statutory fraud, with the various elements of the common law claim put into the statute, reliance, misleading statement, etc., and with this specific identification through the PDMR route of the persons in respect of whom guilty knowledge must be established, either knowledge or recklessness of misleading statements or dishonesty as appropriate. As for the definition of a PDMR, if you turn on to page 12, section 8.5, there's a list of persons who qualify as a PDMR, and the relevant one, so far as we're concerned, is 5A, a director of the issuer. That section was considered by Mr. Justice Miles in a case we have to go back to, Alliance and G4S, and he held that the definition aligns with that of the English company law sense of a director. So it's de jure, de facto, and possibly a shadow director, but not anything wider, as was some of the argument, into some form of senior management responsibility. That's section 90A. Section 90, if you turn back to page 3, this is narrow in its factual ambit, in that it's limited to losses arising from listing particulars or prospectuses, but the content is similar in respect of an untrue or misleading statement in those documents, or the omission of any matter required to be included. It doesn't require guilty knowledge in the same way as Section 90A. It doesn't require reliance in the same way as Section 90A. But there is a statutory defence, that's Schedule 10, which is page 7. Section 1(2), a person is not liable if he reasonably believed the statement was not true or misleading, or that matters were properly omitted. So in broad terms, Section 90 looks a bit more like negligence loss, albeit there's a reversal of the burden of proof, but it's in that territory, whereas Section 90A is the fraud element. Now, this claim, so far as Section 90A is concerned, is brought in respect of information published by the defendant between 2007 and 2019. The information is set out in an annex to the pleading, which isn't in the bundle, but the annex comprises 275 passages extracted from things like the annual accounts or the interim statements published by Standard Chartered. The passages referred to are largely, if you like, generic statements about management controls and internal controls within the bank. The way the claim is constructed is that those passages are then said to give rise to a series of 12 implied representations. If you put away the authorities bundle, if we can turn to bundle, the core bundle, tab 7, page 122. Paragraph 32 of the list of the particulars of claim, and this sets out the 12 implied representations said to be derived from the 275 passages in the published information. And they are in pairs, but you'll see just glancing down at the essentially representations as to the adequacy of various elements of internal control. 32.1 in relation to sanctions and financing, 32.3 money laundering, etc. So the case distills the statements into this series of representations as to the adequacy of various controls within the bank. The claim then says that those representations, i.e. the implied representations, were untrue and misleading because of certain undisclosed misconduct within the group. And there are 3 species of misconduct which are relied upon. The first species of misconduct is conduct the subject of regulatory settlements in 2019. And these are described in the particulars of claim. If you turn back to page 114, from paragraph 20 onwards, the detail doesn't especially matter for the moment, but in brief, there were regulatory settlements in 2019 concerning breaches by the bank, Standard Chartered Bank, of US sanctions law in relation to Iran during the period of 2007 to 2014. Principally, there were 2 species of misconduct identified in these regulatory settlements. First, a failure by the bank to prevent access by Iranian entities to online trading platforms. Therefore, they could trade through these trading platforms without sanction. And secondly, the processing of US dollar payments on behalf of certain Dubai companies, which were in fact acting as fronts for Iranian entities. So there were broadly two main species of misconduct, the subject matter of the settlements. The 2019 settlement, the conduct which led to the 2019 settlements was admitted by the defendants. So that's not an issue in the action. So that's the first species of misconduct. The second species of misconduct, which form the subject matter of a fair amount of my submissions, is alleged conduct, which was the subject of a legal complaint in the United States by Brutus Trading LLC. And that's pleaded, just to touch on it, we will come back to it at page 118, paragraph 24. And in very short form, for the moment, this was a complaint notionally on behalf of the US government, in which Brutus, a special company, special purpose vehicle, alleged that the conduct of the bank, Standard Chartered Bank, was much more extensive and much more serious than had been recorded in the 2019 settlements. To put that in context for the moment, and say we will come back to it, if you're still on paragraph 24, if you turn back to page 114, paragraph 21.1, this is a description of the first of the 2019 settlements with the New York Department of Financial Services. And 21.1 records that the regulatory settlements concerned an additional $600 million of payments in violation of sanctions. So that's the really serious matter, but that's the scale of the regulatory settlements. The Brutus allegation, and we'll come back to this, alleges that in fact Standard Chartered Bank illegally processed hundreds of billions of dollars of in breach of US sanctions. So there's a significant add-on, shall we say, through the Brutus allegation. In any event, the Brutus allegations, as you may have seen in the documents, were investigated by US government agencies and found to be, they considered, meritless. The claim has been dismissed in the US with all possible avenues of appeal exhausted. The defendant denies the allegations in Brutus. The claimant's position, as we'll see, is that they're all true. So that's the second species of misconduct. And the third species of misconduct is alleged bribery in a company called Maxpower Group. Maxpower Group was a Singaporean power company operating in Indonesia, in which Standard Chartered entities had a minority stake. An allegation was reported in the press in 2016 that Maxpower had bribed Indonesian government officials. That allegation has never been established, but the claimants assert in their pleading as a fact that there was what they call a bribery scheme within Maxpower, and that the bribery scheme also falsified the misstatements, caused the misstatements. So those are the three species of misconduct: 2019 settlements, Brutus, and Maxpower. There are also allegations, just following through the structure, or parallel to the structure of the Act, of PDMR knowledge to build up the various claims. And if you turn to page 143 of the bundle, at paragraph 72, there's an allegation of PDMR knowledge of what's called relevant misconduct. And the relevant misconduct on the claimant's definition is the 2019 conduct and the Brutus conduct. So an allegation in paragraph 72 of PDMR knowledge of that, and what the claimant has done in its pleading from paragraph 73 is identify, in this case, 4 individuals they allege to be PDMRs of Standard Chartered PLC for the purpose of knowledge of the relevant misconduct. By way of further information, they subsequently identified a further 8. So far as relevant misconduct is concerned, they've identified 12 individuals they plead were either de jure or de facto directors, and who they say had knowledge of what they call the relevant misconduct. Moving on to 146. So far as Maxpower is concerned, so that's relevant misconduct as described. 146, paragraph 75, so far as Maxpower is concerned, there are allegations of knowledge, 75.1 and 75.2, on behalf of the group executive. And it's going to be subject matter of the Maxpower bit of this application, this appeal, to consider the sufficiency or the relevance of those allegations of knowledge of something on behalf of somebody as part of the group executive. This leads on in terms of the pleading at paragraph 77, completing, if you like, the fraud cause of action, that one or more PDMRs knew of the misleading statements or were reckless or knew the omissions to be dishonest, 77, and 78 that knew the delay to be dishonest as well. So that's how they've pleaded together the Section 90A claim. The Section 90 claim is in respect of 3 prospectuses, 2008, 2010, 2015, and the underlying structure of the claim is similar, but obviously they don't have the same allegations of fraud in that respect. So that's the structure of the pleading. Briefly on the legal element of the appeal, and if you can still in bundle, core bundle, turn to tab 5, page 63. This is the judgment of the judge, and to set out paragraph 42 at the bottom of the page, familiar principles on strikeout/summary judgment, which obviously aren't going to be in dispute before your lordships, albeit, to be clear, the basis of the application to strike out, and therefore the basis of the appeal, is not that there are disputes of fact which the court is able to resolve, but that these are allegations of fraud and dishonesty which shouldn't have been pleaded at all. So it's anterior, if you like, to a dispute of fact arising on a summary judgment application. And that takes us to the more specific rules.
Just pausing there, are we concerned with summary judgment at all, or is it only strikeout?
I think realistically it's strikeout.
Yeah.
More specific rules about pleading, in particular, the need to plead facts which are capable of being supported by a statement of truth, and then the particular requirements of pleading fraud in circumstances where the allegations here, in fact, involve a sort of double fraud, if you like. There's the, as far as Brutus is concerned, for example, there's the Brutus conspiracy is fraud number 1, and the PDMR knowledge of misleading statements / dishonesty is fraud number 2. So it's a sort of double fraud. But it doesn't mean very much, but just as a matter of structure, that's what the allegation is. Paragraph 44 of the judgment, page 64, the judge sets out a passage from, I think it was Lord Justice Warby in Duchess of Sussex, as to the need to have, particularly number 3, reasonable evidence for the assertion of a reasonable basis for belief the evidence will be available at trial, as far as a statement of truth is concerned.
Now, can I understand this? One principle in play with allegations of fraud is the principle of professional conduct.
Yes.
A pleader must conclude that it is proper to plead fraud, and in making that assessment, presumably the matters referred to by Lord Justice Warby are highly relevant. In circumstances where a pleader has concluded that he can plead fraud, what is the principle?
Well, we submit it as follows. The question of professional responsibility is, if you like, relevant, well, obviously important, but not specifically relevant for the strikeout, because that will go to other issues of professional responsibility, and the pleader must satisfy himself that there is sufficient credible material to plead fraud. And we know from Metcalfe and Mardell that credible material doesn't necessarily have to be pleaded. Nevertheless, we submit that that's not directly relevant to the question before the court, which is an objective one on the basis of the pleading itself. So the question, Lord Justice Warby's statement is a general statement about pleadings as a whole and statements of truth, rather than specific fraud. But what he is indicating, we submit there, is that in order to sign a statement of truth with respect to pleaded facts, those conditions must be satisfied.
And how far does that of itself matter to us? Statements of truth have been provided. So we're not concerned, are we, with whether or not it was proper to sign the statement of truth?
Well,
and Lord Justice Warby is, I think, was concerned with questions of costs or something, was he? He was concerned with questions of propriety of conduct.
The reality is the general propositions about statements of truth, if you like, introduce the more specific obligations in relation to fraud. And this application is about fraud. So your Lordship is probably right that, in a sense, that's the starting point, that there must be, we say, objectively basis to sign the statement of truth. But the more specific allegation that we're concerned with here is the fraud allegation, and therefore it's the specific rules, the special rules in relation to pleading of fraud, which are pertinent. And as you will have seen from our skeleton argument, we submit two basic propositions. I suspect they may be running in together, and we may be at fault for having tried to separate them out. But the two separate propositions that we say apply to a pleading in fraud is that first, on its face, the pleading must disclose a solid evidential foundation for the allegations made.
Sorry, just hang on. On its face, the pleading must disclose
a solid evidential foundation for the allegations made. I'll show you where that comes from if I can, but that's the first one. Solid, that's on its face. And secondly, when a party pleads fraud or dishonesty by inference, which is of course 99% of the time, that party must plead all the primary facts in support of the inference, and those primary facts must be sufficient on their face to tilt the balance in favor of fraud. I.e., as we'll see in a minute, to make it more likely than not that fraud can be established. So there's a threshold objective analysis that ought to be done to a pleading, and it's quite apart from professional responsibilities. It's simply analysing the pleading. The principal elements were summarised. I think we can take it quite quickly because it's summarised by the Court of Appeal in SOFA, which is tab 14 of the authorities bundle. Page 396 to 397 of the bundle, paragraph 23. This is the judgment of Lord Justice Arnold, which the other two Lord Justices agreed with. And the principles about pleading dishonesty at the bottom of the page 23 was summarised by counsel, or accurately summarised by counsel. In order, you can see fraud or dishonesty must be specifically alleged and sufficiently particularised.
Sorry, I wasn't keeping up.
Sorry?
Where are you starting? 396,
bottom of 396. Yes. Paragraph 23, just the introduction.
Yes,
rules for pleading of dishonesty. Summarised by counsel, but said accurately by the judge. As you see, one, the general point about specific allegation. Two, dishonesty can be inferred from primary facts, provided that those primary facts are themselves pleaded. There must be some fact which tilts the balance and justifies an inference of dishonesty, and this fact must be pleaded, that's Three Rivers, and then developed in a case often cited Mr. Justice Flo in Keckman. The claimant does not have to plead primary facts which are only consistent with dishonesty. The correct test is whether or not, on the basis of the primary facts pleaded, an inference of dishonesty is more likely than one of innocence or negligence. So it's an assessment on the face of the pleading by reference to the primary facts which must themselves be pleaded in order to support the inference sought to be drawn. There is a definition, I mean we found it, there is a definition, Lordship will be much more alive to the issue than me, but there's a definition we found of a primary fact which is referred to in the judgment. If you go back to bundle, core bundle, page 65, 46.5. Lord Justice Denning in a case nothing to do with this one, obviously, an old situation, but in any event, you'll see what he describes there. Primary facts are facts which are observed by the witnesses and proved by oral testimony, or facts proved by the production of a thing, such as original documents.
Does this have anything to do with this case?
Well, it has something to do with this case. That when we go, one of my submissions will be is that they haven't pleaded primary facts, let alone primary facts sufficient to tilt the balance in favour of dishonesty.
Well, can I just understand this? Lord Justice Denning says primary facts are facts which are observed by witnesses and proved by oral testimony, or facts proved by the production of a thing itself, such as original documents. Well, what connection has that got with what we're concerned with?
Well, only this, and so that was a definition that we found seemed to be of relevance because we're talking about primary facts. When we look into the pleading, particularly in relation to Brutus, what we submit is all they pleaded are conclusions. So rolled up conclusions at a very high level. And what you don't find is anything that could be called a primary fact, which could tilt the balance suddenly in favour of an inference of dishonesty.
And I understand that case, but it doesn't seem to have anything to do with this one.
Well, one has to ask.
Here, the Court of Appeal is concerned with appeals, what approach a court should take on an appeal. It seems a very different issue. I mean, take the allegations in the Brutus complaint. It is said that is it Project Green meant such and such?
Yeah.
Is that a primary fact?
Well, it's not a primary fact. It's a conclusion from something. I mean, the primary fact presumably is what is the primary fact? The primary fact, there may be a document indicating what it is. I suppose is that a primary fact. But the assessment, Project Green, is part of the conspiracy. Involves in it, of course, the conclusion that there is a conspiracy, which isn't a primary fact.
I mean, plainly, that is something that could be proved by evidence such as Lord Justice Denning is referring to. But there's no obligation on the pleader to plead evidence.
No, but you do have the obligation to plead the primary facts in which an inference of dishonesty is to be drawn.
And if you plead Project Green within Standard Chartered was understood to mean such and such, is that not a primary fact, regardless of how you're going to prove it?
Well, it depends what it's understood to be. Because if the sense is it's understood to be part of a conspiracy, for example, then you're immediately introducing into your allegation that there was a conspiracy. So you can't simply say the understanding is a primary fact. Understanding of what? And it's the conspiracy bit, it's the dishonesty bit. I mean, what the project name was called, in a sense, is a bit of a sideshow. But insofar as it involves an assertion that there was such a conspiracy, then that clearly isn't a primary fact.
It's quite often said that conspiracy is difficult in itself to prove, to demonstrate. So you infer it from overt acts.
Yes.
And what you're obliged to do is to plead the overt acts and then infer conspiracy from that.
Yes.
But if you can actually allege conspiracy, A and B agreed on a particular date to do X, then you don't need to infer it from the primary fact.
Your Lordship is right, and going back to the test that we looked at in SOFA, the court's concerned in that situation with an inference of in that case, dishonesty. If your Lordship has, you're right, if your Lordship has a primary case that there was in fact, for example, a conspiracy, then that isn't an inferential case, it's a case which itself is born out of whatever the primary facts are to demonstrate it. Of course, this case isn't just about conspiracy, of course, it's about dishonest knowledge about conspiracy, etc. So one still gets into the inferential bit of this case. But even if there were that case, but your Lordship's right that if there's primary evidence, you have to worry about inference. But in that case, of course, the primary evidence must be sufficient to give rise to the case.
Well, let me understand that. So suppose that a witness tells a potential claimant there was a conspiracy. And on that basis, the pleader thinks he can prove, he can properly plead the conspiracy, and he does so. Is the court concerned to assess the adequacy of the basis on which that is pleaded?
Yes, we would submit yes.
Because
what? For two reasons. First, the court is concerned to ensure there is a solid evidential foundation to the claim. And my submission is that merely because someone else makes an allegation, that doesn't amount to a solid evidential foundation for such an allegation.
Well, when you say someone else, suppose for the sake of argument, is you have a witness with personal knowledge. It's not just someone else making the allegation. Here's someone saying, I know because I was a witness to the events.
It may depend on what the witness does know or doesn't know. If the witness says, I've looked at documents and my conclusion is X, Y, Z, for example, then it becomes more difficult. If it's I've seen X and X happened, then that's on a simple case that may be different. But on a more complex case, simply because, in this case, for example, Brutus makes a series of allegations, we submit that by itself isn't a solid evidential foundation to bring us into this action. I have to show that when we get onto the allegations that are being made. But also, even in your Lordship's example, one still has to ask is, are there sufficient primary facts alleged from which the relevant inferences can be drawn? And that depends what the allegation is, of course. One has to consider the allegation in terms, and it may well be that simply because someone has said something, that doesn't give you enough primary facts to draw the series of inferences which are needed. But again, it depends. The devil may be in the detail on that one. Can I also show you, in the authorities bundle, tab 13, because it's sometimes said, and rightly said, that in some situations where there's often called an asymmetry of information, a pleader has a more, or the court gives a more generous approach to pleadings before disclosure. And one can see that often in cartel cases in particular, where the essence of a secret cartel obviously is its secret. And this was considered in the fraud context in the Barclays case. And if you turn to page 366, and the context here was it was a strikeout on limitation grounds. The LIBOR setting bank sought to argue that the claim was brought too late because the expiry period was well gone. The claimants relied on section 32 of the Limitation Act and said there wasn't enough information in order to bring a claim earlier. The defendant bank, as you'll see in page 366, paragraph 32, said, well, hang on a minute, you've got a generous approach to pleading, so you could have pleaded this claim earlier. And so this is a case where the defendant sought to rely upon the generous approach to pleadings and referred to the decision of Mr. Justice Sales in Nokia, where he talked of, as you'll see in paragraph 34, in broad terms, the fact that cartels are secret, and therefore there must be some give and take on a pleading front when they come to be pleaded in the absence of actual information before disclosure. 35, the judge said, Mr. Justice Sales is not dealing with the same issue which I am concerned. Although he contemplated a measure of generosity concerning pleading should be given to claimants in competition cases, he nonetheless made clear this generosity depends upon certain procedural protections, identified in particular requirement that defendants should not be subjected to allegations of fraud or dishonest conduct without sufficient material being available to those who plead statements of case. And he then went on to the dishonesty cases, referring to, first of all, Playboy Club, which was also Mr. Justice Sales, in fact, Lord Justice Sales at that point, where he referred to the need for, as you'll see at the top of the page, a solid foundation in the evidence. He then referred to Three Rivers, he then referred to Keckman, the cases dealt with in SOFA. And at 39, from the authorities, I believe the protections which Justice Sales was referring in Nokia are that parties should be reticent about pleading allegations of fraud and deceit and should not do so without a solid foundation in the evidence, which Mr. Justice Sales contrasted with speculation. That's where we've extracted our principle about the solid foundation in the evidence.
Now, can I just understand that? I mean, arguably, that's dealing with professional responsibilities. You cannot properly plead something unless you think there's a sufficient foundation for it. We're not concerned with professional responsibilities. We're concerned with the adequacy of the pleading. Does this bear on what is an adequate pleading?
Well, that's why I said earlier, it may well be we've extracted 2 points, which are really 1 point, because if one starts with the primary facts issue and asks the question, are there sufficient, first of all, is this an inferential case? We say it clearly is, and we'll look at it. Secondly, are there sufficient primary facts pleaded which tilt the balance in favor of fraud or dishonesty, which is the test? If the answer to that is yes, then on the face of it, there's a solid evidential foundation for the pleading, I suppose. So it may be the points are the same. If the answer to that is no, there isn't a solid evidential foundation for pleading.
Well, I find what one can draw from Playboy Club, Lord Justice Sales's analysis, paragraph 46, slightly difficult, because he starts off by saying courts rather than improper react adversely where speculative claims toward a bandied about, and the necessarily risk losing goodwill. But he ends up by saying in the last sentence, although the club could have pleaded deceit before trial or negligence claim, in my view, it behaved reasonably improperly in deciding not to do so on the speculative and inferential basis, which would have been necessary at that stage.
Yeah.
It suggests that he thought it could have been pleaded on that basis.
Well, I agree that that sentence is difficult to square with what he said earlier, but there's nothing, just looking at the words he used, there's no other authority, as I'm aware, that suggests that it's appropriate or that you can plead fraud on a speculative and inferential basis.
But you can plead it on an
Inferential basis, yes,
we know
but
that.
not on a speculative basis. And speculative
Can I disentangle things again? I mean, a pleader can't plead fraud without thinking he's got enough reason to do so.
professionally.
But that's not what we're concerned with. If he does in fact plead A, B, C, we'll assume it's an inference case, therefore we infer fraud. Is the court concerned to look behind A, B, and C to see whether there's evidence to support A, B, and C?
No, the court would only, if an issue arose about the pleader's actual professional responsibility, that's a different issue. That's a Metcalfe and Mardell. On a strikeout, the court is simply concerned to look at the pleading. So the question is, going back to the Keckman test, on the basis that the primary facts pleaded, are those sufficient to tilt the balance in favour of honesty or dishonesty? So that's regardless of the professional responsibilities.
Yeah. So if the pleader says A, B, C, therefore fraud, the court is not concerned to look at whether there's an evidential foundation for A, B, and C, but it is concerned to see whether A, B, and C are capable of justifying the inference.
Well, I wouldn't go expect that far, because there must still be a question whether A, B, and C are themselves properly pleaded.
But that's then more than would always arise when facts are pleaded. You might be able to show that they're not credible by evidence. Or striking.
Yes,
That's a high test, isn't it?
it is a high test, but what we have here is a rather different scenario we submit, where, even assuming A, B, and C are pleaded, that's something you say they aren't, we know the only basis for the plea, as we'll look at the pleading, is that this allegation has been made somewhere else. And we do submit, after about this obviously, that it's an inappropriate basis for a fraud claim simply to advance a case on the basis, and this is the only basis it's put, that someone else has made the claim somewhere else. So, in answer to your question, the A, B, and C themselves require some scrutiny, quite apart from the second question, whether, even assuming A, B, and C, do they tilt the balance in favor of fraud? Maybe it's why we disentangled the two elements. It is an unusual case in that the basis on which it is advanced is unusual, and we say inappropriate. But secondly, the way it's also put, we say fails the test. So can I just say something now, moving on to the Brutus complaint itself, and I hope reasonably briefly, but I think it's important to put some of this in context of the submissions I'm going to make. And if we can turn up these supplemental bundles. There were two complaints by Brutus. The first was made in December 2012, and it's a claim under what's called the False Claims Act, in which a third-party relator, as described, can bring an action on behalf of the US government and can seek up to 30% of US government damages. At the same time it brought the complaint, we know that the principals behind Brutus gave their materials to the US government agencies, and there were 5 of them. The US government agencies concluded the allegations were meritless, but the file was sealed whilst they undertook a different investigation, which ultimately led to the 2019 settlements. So that's the sort of sequence of events. The first complaint was withdrawn without prejudice, and then a second complaint was brought in 2018, which was subsequently amended into its final form, which you'll see at tab 3, page 33. Just so you can see the shape of the claim, at paragraph 8 on page 35, there's the allegation that Standard Chartered Bank moved hundreds of billions of dollars in thousands of transactions subject to US economic sanctions because of their links to Iran. That is said to give, each transaction is said in this complaint to give rise to an immediate forfeiture of the US government of the amount so transacted. As you'll see at the bottom of paragraph 8, the amount of each illicit transaction became at the time of the transaction an obligation of SCB to pay or transmit money properly to the government. And that's the False Claims Act claim. And therefore, if you go to paragraph 11 on page 36, the complaint is for damages in the amount of money forfeited by reason of those transactions, all trebled. So the amount of the complaint in Brutus is for treble hundreds of billions of dollars, which Brutus wants a third. So it's a third times 3 times hundreds of billions of dollars. The basis of the allegation of Brutus is of a pervasive conspiracy, and this is back to Lordship's question as to what is being alleged here. If you go to page 44, and beginning at 41, the scheme to capture the lucrative rewards that depended on SCB evading sanctions. Indeed, evasion was the service offered by SCB was far more robust, cunning, and extensive than the picture presented to Justice Department authorities in negotiating the 2012 DPA. Just pausing there and interrupting that. Your Lordship may see where I'm going in terms of primary facts, just bear in mind the way these things are being put. 42, the course of conduct was no haphazard affair, the handiwork of deliberate and concealed organizational structure. There's a reference, Your Lordship mentioned it, to Project Green, but it's explained a program run by trade finance experts and senior geographical branch chief executive officers, deliberately excluding compliance officers. And then further down, Project Green was designed to assist, conspire with, aid and abet non-United States customers to evade sanctions, etc. Over the page in 45, there's something else about the Origins and Client Coverage Group, which was deployed to create fraudulent records. And then at the end of there's a reference to winding down transactions. The law does not allow for the winding down of illegal sanction transactions. These transactions are crimes that must be halted. And then if you turn to page 55, is the prayer. And the prayer seeks the relator maximum amount, which is paragraph 3, which is the 30%. And that's where we get to the 30% of 3 times hundreds of billions of dollars. So that's the Brutus complaint. Procedurally, the US government filed motions to dismiss the complaint, and in support of those motions, filed various statements of evidence from those involved in the investigation who had concluded that they had no merit at all. And just to explain, I'm going to show you some of that, but in support of my submission, not that Your Lordship is going to decide who's right and who's wrong or not. But
well, we can't.
Of course you can't. I'm not going to
be a mini trial.
Of course, exactly right. That's not the basis of the application. But going back to the question of solid evidential foundation, can a pleader simply plead, someone told me X? We submit, first of all, no. But secondly, not no when one knows that the X is itself controversial. And the pleader must do more, we submit, on the face of the pleading at least, to give some indication of why X might be right and Y might be wrong.
Now, I'm not sure why that should be so. I mean, I quite see, if you were applying for summary judgment on the basis that there was no real prospect of success in these allegations, one might be concerned with what the US authorities thought about them. But we're not. And we're not concerned either with whether the pleader could, as a matter of professional conduct, conclude that there was a sufficient basis for making the plea. So what you end up with is allegations made in the complaint, in respect of which we do have statements from Mr. Knight and Mr. Chandra, is it? Then you find on the other side the US government witnesses saying, we don't think there's anything in this. But why does that arise on a pleading point?
Rising at the pleading point, we submit as follows. Leave aside the primary facts issue, which is a separate issue from that. But on what we call the solid evidential foundation point, we submit as follows. First, as a matter of principle, all that the claimant has done here is pleaded this case because Brutus has pleaded this case. And we submit as a matter of principle, that is not a solid evidential foundation for a fraud claim. So that's my, if you like, my principal point. But we also submit that, well, either the argument is, well, especially in a case such as this, or at least as illustrative of why it must be right, one can look, we submit, to the fact that we know that this is a controversial claim. Let's take one example about this. One of the main responses of the US government to the Brutus complaint was they simply didn't understand US sanctions law. So forget the facts, if you like. As a matter of US sanctions law, they misunderstood what the law was. And there's a long statement, 2 long statements in fact, from the director of the relevant department who gives guidance on US sanctions law, who says time and again, Brutus has simply got this wrong. Now, when one comes to this pleading, all one sees from the claimant is, well, Brutus has made this claim. If one asks the question, is there a solid evidential foundation for claimants to make that allegation? We submit they must at the very least engage with the issues which have been raised. They must engage with the issues, for example, whether anything that Brutus says does demonstrate a breach of US sanctions law. That would, of course, be a matter of fact, which ought to be pleaded in any event.
How does that engagement manifest itself?
Well, it would manifest itself in this case, had this been properly pleaded, had the claimants properly, we submit, advanced this case if they could, they would have had to plead, for example, US sanctions law was as follows, as a matter of fact, US sanctions law was as follows. The following transactions happened. The following transactions were a breach of sanctions law for the following reasons. Individuals knew about those breaches because of these facts. PDMRs had knowledge of those breaches because of these facts. The whole sequence of factual pleas which would have been made, and we submit ought to have been made, were a proper pleading of this nature to be advanced. What we have instead is, well, Brutus say it. And we say Brutus say it can't be enough anyway, but it certainly can't be enough when we know that this is a controversial statement at the very least. And we know, or at least there's nothing in the face of the pleading to suggest, the claimants have even asked the question whether Brutus is right and the US government is wrong.
Well, that's something we can't know.
Well,
we can't know what questions they may have asked themselves, unless you're saying that they should have pleaded in some way, well, we have questioned whether this is right.
No, your lordship's right. I maybe put that too far, subject to one point, which I'll mention in a minute. What they ought to have pleaded is what I said earlier, the sanctions law and the breaches of sanctions law. At least then we'd have something to deal with. And we could look at that, see whether it made out.
That's on that point that you say what was actually being pleaded is inadequate. I'm not sure how one can introduce a test that they must have interrogated the accuracy of what was being said. I just don't see how that objectively can be judged, particularly given issues of privilege and relevance.
No. Well, you're right. Your lordship's right. Maybe I put that too high. Standing back, we do submit, you can't just piggyback on someone else's claim full stop in a pleading. You need to plead out the relevant facts. They haven't pleaded out the relevant facts, so in a sense, we would say game over at that point. What questions they've asked to get there or not asked to get there, your lordship's right, it's behind the counter, and I can't, behind the curtain, and I can't go there, save for the fact that, and it's not really part of my appeal, albeit it's part of the judgment, there is evidence from the claimants as to a long statement from the claimants about why they think it was reasonable to plead what they did. And that statement doesn't indicate any interrogation of these questions at all. So I can't go any further than that. It is, we say it's not really relevant on the strikeout application anyway, the judge was wrong to take into account. But there's nothing, certainly nothing on the face of the pleading to suggest that relevant questions have been considered, because nothing on the face of the pleading considers those questions. That's why I wanted to show you, Lordship, subject to maybe for 5 minutes or so, just what the US government says about this. Not because it's right or wrong, but because it highlights the controversial nature of this claim and emphasizes, therefore, the need, if it were properly pleaded, to plead out facts which support the case, as opposed to simply relying upon a claim which is itself heavily in dispute. Now, maybe I can deal with this quicker than that if I just show you the manful statements, because that deals specifically with a sanctions point, which says one finds nowhere in the pleadings. If you turn to supplemental bundle tab 7, page 80, Mr. Manful, as he explains, is the multiple positions in the Office of Foreign Assets Control since 1997. At paragraph 2, he manages all aspects of the division, including providing guidance on the applicability of sanctions to financial institutions. He then, in his statement, gives various explanations about the sanctions regime. And if you turn to page 87, page 87, paragraph 20, he says that SCB as a foreign financial institution has multiple options for winding down its pre-existing obligations with Iranian clients. For transactions related to US dollars, there's something called the U-turn general license. And he said otherwise they could make or accept payments in currencies other than dollars as long as they didn't involve the US financial system. So he's explaining in a statement why there were wind down options. That's why I showed you earlier the Brutus complaint, which said, as a matter of US law, you can't wind down transactions, they're all illegal. So you've got a dispute specifically on that. If you then turn to paragraph 25, on 89, he explains the investigation that was undertaken. SCB set a number of wind down reports. The reports explained how SCB was going about winding down the customers and trade relationships in a manner compliant with the rules. In the bottom of that paragraph, OFAC had no objection to the manner in which SCB wound down these kinds of relationships. And if you then turn to tab 12, his second statement, which was in response to that's something that Brutus said, and just very briefly, you'll see if you go to 168, the sequence of this in relation to the question of US law. So he says at 13, Relator's opposition inaccurately, at 11, Relator says something about transactions involve benefit individuals subject to sanctions must be blocked. That is not accurate. 13, Relator's opposition inaccurately describes the requirement of the general license. Paragraph 14, contrary to Relator's description, this general license did not require the involvement of two different foreign banks, didn't foreclose foreign banks. And then 17, over the page, Relator is thus incorrect that non-US banks, such as SCB, were prohibited from engaging in wind down transactions, etc., nor, contrary to Mr. Knight's statement, is the mere fact that a foreign financial institution accepts the repayment of US dollar-denominated obligations in another currency constitute a sanctions violation. And then 19, not objecting to wind down outside the United States and consistent with US government sanctions policies. So as I say, I don't put that to say to your lordships, well, the very person who gives advice on sanctions regime must be believed, but at the very least, there's an issue here. And at the very least, we submit, you can't just plead a case that says, well, Brutus says it, without engaging in the very point in issue. Just following it through on the sequence, and we'll go on to the pleading in a minute. As you may have seen, the US District Court dismissed the claim. Brutus appealed. At the same time, there was another appeal in the Supreme Court about the test, which doesn't really matter. It's agreed that the test for dismissal was a low threshold. There's no doubt about that. And it wasn't a merits-based decision. No doubt about that. Last document there, after the Supreme Court decision on the test, there was the opportunity for Brutus to put in further submissions to the appeals court to explain why basically it was right and the US government was wrong. And that letter is at tab 16, page 206. And this also goes to a point I'll make in a minute, but the answer given by Brutus as to why there should be an appeal and it was right, etc., was essentially that the US government's evidence was all a lie. So if you go on page 206, a letter from their lawyers to the appeals court, and 207, just to get a flavour, at the bottom of 237, they say that it wasn't a conflict of, the previous case didn't have a conflict of facts. Indeed, that factual conflict was created in this case by the government's gross misrepresentation of the relevant facts, chronicle of government's egregious mendacity, bad faith and fraud in the court, not evident in Polanski. And there are various other similar contentions. If you go to 212, letter G at the bottom, the defining context of this case is sharp conflict in the record, amplifying that conflict to the government's misrepresentations, that is lies to the district court about the extent and detail of the evidence, etc., which is the fraud on the court. That was how Brutus sought to respond to the answer. Now, we can put that away and go back, please, to the core bundle, back to the pleading. Core bundle, tab 7, page 118. And it begins at paragraph 24, the Brutus pleading. And your lordships will note that the form of wording in the Brutus paragraph 24 sets out the fact that there was a report of the case, and then it says the complaint alleges, amongst other things, that. So on the face of the pleading, the claimants seek to bring into the action the fact that Brutus has made these allegations. And that's that. And there's then a summary of some of the allegations contained in the Brutus allegation. One point to note here, and we won't go to the transcript, it was explained before Mr. Justice Michael Green, that this paragraph represented the evidential base for the pleading of fraud. And it was said that it doesn't include all of the Brutus allegations, just the Brutus allegations specifically identified in these paragraphs, and that is the evidential base, or it's put the facts on which the misconduct allegations are made. And that then leads, according to the structure of the pleading, to paragraph 27, which are said to be the particulars of misconduct, or the particulars of fraud, which are, as you'll see, very high-level summary of allegations at paragraph 27.
And you're asking to strike out 27.1 and 27.2.
Yes. The reason, just to be clear, when we applied to strike out, we sought to excise matters relating to Brutus. So, for example, we seek to excise all of 24. And if 24 is the evidential base for the allegations relating to Brutus, then Brutus must disappear from the pleading. The reason, and the judge seemed to find some difficulty with this, the reason we picked on 27.1, 27.2 is that we understood those were specific to Brutus, whereas 27.3 to 5 also applied, as we read them, to the 2019 settlement misconduct. That's the reason why we did that. But the basis is we sought to excise anything to do with Brutus, leaving behind the agreed 2019 conduct.
27.2 refers expressly to Brutus.
Yes.
27.1 doesn't.
It doesn't, but the 2019 conduct doesn't refer to deliberate and or systemic course of conduct in breach of sanctions with a view to evading them. That's a summary.
So you inferred from that meant
It's what we saw in paragraph 42 of Brutus. Rightly or wrongly, that's the reason we chose to do that. But the principal point is 24 we submit ought to go, and if the evidential base goes, Brutus must go. Now, the only other point on the pleading, if you go to the reply, page 119, sorry, page 299, we did take some issues of what we did ask exactly what was being alleged in relation to Brutus. And 23.2, it denies the additional allegations of misconduct in Brutus are false. And at 23.2.3, it pleads the claimant's position that the additional allegations of misconduct are accurate and will be found proved following disclosure and oral evidence in these proceedings. So that's all we have in the pleadings in relation to this Brutus allegation. First of all, pleading, this is what they've alleged. And secondly, their position that it's accurate. And that takes us to our grounds of appeal, as you know.
So just to be clear, maybe this is not a question for you, but as you say, originally what was pleaded was this is alleged. So the fact alleged is the allegation. This takes it somewhat further. Do you say there is still no averment that the facts stated, the relevant facts stated in the Brutus complaint are true?
Well, I do say that as a matter of strict reading of this pleading, but that's not, I'm not going to hang my hat on that as a basis of appeal, but the reality is, look at this pleading. The first pleading, which is the Particulars of Claim, of course, simply alleges this is the allegation. This pleading identifies their position. Now, their position can be all sorts of things. It may well be true that that is their position, but is that a pleading of those facts? As, let's say, strictly speaking, we say it isn't, and therefore there's a technical problem here. But I'm not here to argue, to ask, to succeed on the appeal on that technical point alone, at least. But this is a starting point to see what is actually pleaded, and one sees at the very least a very tentative approach to this pleading, and no doubt rightly so. But that's it. In answer to your Lordship's question, I don't accept that, but I'm not going to spend a lot of time trying to get to the bottom of it.
So for our purposes, what really matters, you tell me I'm wrong, what really matters is whether, well, put it this way, supposing that the material parts of the Brutus complaint had been incorporated in the particulars of claim, would there then have been an adequate pleading?
I think realistically I have to accept that's the right question to ask. So we say, grounds of appeal, I say I've separated them out into two, but it may be one, but for the sake of the analysis, our first ground of appeal was what we call the speculative allegations point. And we do submit as follows, and I've prefaced some of this already, so you know what's coming, whether you like it or not. First is we submit as inherently problematic, and we say incompatible with the rules of fraud pleading, for a party to make serious allegations such as this, and these are as serious as you can imagine, solely on the basis, at best, but solely on the basis that such allegations have been made by someone else in some other claim, especially in a foreign jurisdiction. So on the face of the pleading we submit, that doesn't demonstrate a solid evidential foundation for the allegations, because the thread on which it is based is inadequate. The fact that the claim has been made somewhere else may be sufficient to start an inquiry, but we submit that the pleading must do more than that, and more than rely upon the fact that a claim has been made. Otherwise, we submit, such a claim is by definition unverified speculation, because it's based on the hope that claims made by a third party might have merit. But that's all that this claim is.
Insofar as they were English proceedings that you were basing your claim on, those would be verified by a statement of truth and would be admissible as evidence, therefore, certainly in those proceedings. So someone who brings a claim based upon that particular claim would be basing their claim upon evidence.
It would be based on evidence, what your Lordship is right.
I find it hard to see. I can see that you might be able to undermine it in some way, but I can't see anything wrong in principle in somebody, say for example there was an allegation that a bank, an English bank, had been systematically defrauding its customers, and there was a properly pleaded claim against the bank, so saying, and then other customers brought proceedings adopting exactly the same allegations of systematic fraud. I find it hard to see why that would be objectionable, particularly as one wouldn't even know from the pleading itself what inquiries they had or hadn't made as to the legitimacy of those allegations. Just the fact you've adopted somebody else's claim, don't see a problem with it.
Your Lordship, you may be right. Your Lordship is right. It may, and ultimately I may have put that.
It's contrary to what you're saying, so I don't think you can accept it.
No, for this reason, I think it's possible that that first submission I put too high, certainly in relation to an English claim where there is that evidential piece, that it's not objectionable in every circumstance to follow a plea of adoption. And there may be circumstances, if there's a properly pleaded English claim, for example, with evidence in support of it, that is a route that can be taken. But that's not the position we have here.
This is quite a fine distinction, then, isn't it, to say that because the US proceedings don't have a statement of truth on it, and that what they do have is support in the form of witness statements from persons who say, well, this is our sworn evidence to back up these allegations.
Well, this is where it may be, the answer to the question, I agree or not agree, it may be a matter of acceptance of degree. Because what we have, and going back to the point I mentioned earlier, what we have in this situation is we know this is a controversial claim. We know there are big issues about this claim, for example, about the US sanctions law. There's nothing in this pleading by mere adoption or by a position that Brutus is right, anything on the face of this pleading to give it a solid evidential foundation beyond the fact that Brutus have made a controversial claim. So,
but one has to be wary there, doesn't one? Because take my Lord's example. Suppose the English claim is brought, properly pleaded, and the bank puts in a defence saying it's rubbish. That doesn't of itself, does it mean that the other customer can't put in a pleading in the same terms?
well, it may depend on what the rubbish is. So here we know, for example, the rubbish is the whole sanctions law analysis is wrong.
Well, arguably so.
Sorry, arguably so, yes.
We just don't know. We don't know what inquiries the claimants may have made that persuaded them that those points are bad.
No, but we submit that in order to advance this case in circumstances where we know this is a controversial claim, to bring a solid evidential case on the face of that pleading, they would have had to plead out, for example, the sanctions law. They would have had to plead out a case that demonstrated, arguably only, but arguably, that there was such a breach of sanctions law. And that's why I say maybe I put it too high as an absolute, but if one looks at the circumstances of this case, it comes from abroad, it doesn't have a statement of truth attached to it. It is a controversial case where it has been brought. In particular, some large issues have been raised which have not been addressed in this pleading. And we submit that then takes it into the speculative rather than the founded case. Because we just don't, you're actually right, we don't know what inquiries have been made. There's nothing on the face of the pleading to suggest that this claim has any merit to it other than speculation.
Well, we're not, at this stage, we're not concerned with merit, are we? We're concerned with whether it is properly pleadable. And if this claim had set out the Brutus pleading, let's take it that for these purposes it is incorporated, then it seems to me it would be difficult for you to say that there wasn't a properly pleaded case, albeit that you would say that it's one which has been debunked, thoroughly debunked, you would say, by the party by whom it was purportedly brought. For whom?
Lord, yes, but I would...
Is that enough to say that on a strikeout stage you can just dismiss it?
Lord, we do say yes, because in such circumstances, we submit as a matter of, and this is where we put it as a matter of principle, in such circumstances, not adequate simply to say, it doesn't provide a solid evidential foundation for that claim, simply to say Brutus has made these allegations, we think they're all true. When one knows...
Let's imagine we cross out all the references to Brutus said, etc., etc. Cross all that out because it's, as it were, it's not really relevant, and just simply have set out the allegations which were, as a matter of fact, made by Brutus. And it doesn't preface them by saying these were made by Brutus. It just simply set them out, what would be the objection to that?
Well, first of all, one ought not, in my submission, to cross out the way the case actually pleaded. But secondly, it still wouldn't be enough knowing that those allegations need to be addressed. So the pleading would still need to, we submit, deal with, amongst other things, the US sanctions law issue.
Now, can I just think about that for a moment? So suppose that you have a claimant who puts in a pleading saying this happened and it was a breach of the US sanctions regime. Now, you could plausibly say, as you have been sort of saying, well, really, they ought to explain quite what the sanctions regime is and why it was a breach. But is that a basis for striking out, or is that really a basis for asking for further information such that you say, well, which bits of the sanctions regime do you say were broken and why?
Well, it's symptomatic of the problem we submit here, and go back to my Lord to Phillips' point, you can't just cross out the way it's being put. The way the claim has been put is, this is Brutus's case. It's symptomatic of the problem, and one of the points taken by the judge was we didn't ask for further information. On the face of it, there's no further information to give. The claimants know no more about this case than we know about this case because they've only set out what Brutus has said or what those statements say. So it's symptomatic of the problem that a claim has been advanced on the face of the pleading solely because someone else has advanced it. So it's not simply a matter of they haven't quite pleaded a case which they could have advanced. They've proceeded on this basis, we submit on the wrong side. So that's where we put our first submission, that simply piggybacking on Brutus in such circumstances doesn't provide a solid evidential foundation for the claim.
And if that's what you say on that first submission, is this a convenient moment for us to rise for 5 minutes? Spell check.
Well, this second ground of appeal is what we described the absence of primary facts points based on the Keckman analysis and so forth. And it builds on the first point. So the first point, as you know, first ground we submit, you just can't do this at all. But second, even if you can do it, even if in principle, in my Lord Justice Phillips example, if you have a properly pleaded English case, value of adoption, does that work in this case, given what they have in fact done? And for these purposes, I'm prepared to proceed on the basis that there is this adoption by way of the pleading, and that's not a technical point I want to take. Nevertheless, if one goes back to the pleading itself, on page 118 of the core bundle, the question to ask is, have they pleaded sufficient primary facts to tilt the balance in favour of fraud? We submit that they haven't, because what they have pleaded are not primary facts at all, but just a series of conclusions drawn from the Brutus complaint. And that ultimately may be the real vice of so much of this pleading, and the answer to my Lord Justice Phillips' point is that even assuming this can be read as an adoption of the Brutus complaint, the Brutus complaint isn't an English pleading. It doesn't comply with English pleading rules. It's a collection of assertions and conclusions in New York, and would never be enough for an English fraud pleading. And therefore, the adoption of such a document in this proceeding, if that is what's been done, can't be fit for purpose. So if one then goes to page 118, paragraph 24, the evidential base, so-called, and no doubt the alleged facts from which the allegations are drawn.
I mean, if as you say, for this purpose, we sort of pretend that Brutus' complaint has been adopted, incorporated,
Yes.
We need to have that open at the same time.
We need to have that open at the same time, which is supplemental bundle 3, and we can pick it up, I think, at least the first one is page 52. So primary facts in support of an allegation of dishonesty, 2 allegations of dishonesty. And 24.1, 2019 settlements addressed a relatively small subset of the course of conduct by the bank in violation of Iran sanctions. That is, even on its face, at best a conclusion from something that preceded it. And indeed, in the Brutus complaint, if you go to page 52, where it's drawn from, paragraph 66, is the 2019 DPA thus addressed a relatively small subset of the course of conduct. So even in Brutus, that's some form of conclusion. We then go back to 24.2. In fact, the bank's course of conduct in developing its Iran business was a deliberate, concealed organizational structure known to high-level bank officials as Project Green. And the difficulty one can immediately see with this is that isn't an allegation of primary fact or anything close to it. It's a wrapped-up allegation of a series of conclusions. Organizational structure, what does that even mean by whom? Who organized it? What was the structure? Deliberate, how was it deliberate? Who had the deliberation? Concealed, how was it concealed? Who concealed? Each of these conclusions is wrapped up in a series of allegations. This is obviously a critical conclusion in Brutus, that there was this structure, industrial structure, involving evasion of sanctions. But one doesn't get there in English pleading rules simply by alleging the conclusion. One can imagine an English pleading along the lines of this as an executive summary, perhaps, to say, well, this is where I get to, or possibly a conclusion at the end of the... But traditionally, in support of the allegations, we rely upon the following overt acts, facts and matters or otherwise. So the conclusion is pleaded rather than the facts. And if you go...
Sorry, yes.
Sorry. I'm going to go back to Brutus. Sorry, you lordship to something?
I was going to...
Yes, if you go back to Brutus, which is page 44, I think. And the reference is to paragraph 42A. And 42 starts the business, or starts the allegation of deliberative concealed organizational structure. And we say that is, again, the conclusion. But what you get in the subparagraphs are no less broad statements of conclusion rather than anything that could be characterized as a primary fact.
Well, can we just look at that? So 42A Since at least 2002, SCB operated a program known internally to high-level SCB officials as Project Green. Primary fact?
Well, yes, I'm prepared to accept that could be a primary fact, albeit it's a slightly diverting point, the Project Green point, because it was the fact there was a Project Green itself is not going to be in dispute.
No.
It's just what was its purpose.
This was a program run by trade finance experts and senior geographical branch chief executive officers deliberately excluding compliance officers. So I imagine the bit you don't like is deliberately excluding compliance officers.
Yes, of course, because
But
a primary
why
fact
isn't that a primary fact?
well, because it's simply a conclusion. A primary fact would be X did Y. This was by way of exclusion. It was deliberate because of ABC. So the underlying allegations are the facts. The deliberately excluding is the inferential piece of dishonesty.
Well, is it, or is it just you're asking for the evidence in support of the exclusion?
But
There is surely a distinct averment that compliance officers were deliberately excluded, and that feels like a primary fact.
no, the difference is that because this form of pleading doesn't distinguish on its face between allegations and inferences. But this is, we submit, properly analysed, an inference of dishonesty. The deliberate exclusion of compliance officers from some scheme that is otherwise reprehensible. So that, in English terms, requires either primary facts of deliberate exclusion or primary facts from which the inference of deliberate exclusion may be drawn in circumstances in which, remembering the test, the primary facts must tilt the balance in favour of dishonesty. And this is just an assertion. And it's not an answer with respect to say, well, it's an assertion of deliberate conduct, therefore that's enough. Otherwise, in English terms, you could just plead anything. You could plead X is a fraudster, and that's, in a sense, an allegation. There it is. But that's not an allegation of primary fact. You need the primary facts from which the inference is drawn. And this is an example of exactly this problem. That as soon as you start talking about deliberate or dishonest or improper conduct, that you must plead in English eyes the facts from which those inferences, serious inferences, are drawn. And if they're not pleaded to tilt the balance, the claim has to go. And so on. So Project Green was initiated in the headquarters, well, in a sense fine, but I'm not sure that shows a conspiracy. It was headed by somebody. He considered it to be a major new market, was designed to assist, conspire with, aid and abet non-United States customers. So again, exactly the same point. That is a conclusion of dishonesty within which is wrapped up a whole host of allegations. Who designed it? How did they design it? What was the evidence of dishonest intent, if that's what's alleged? What's the evidence of conspiracy? With whom was the conspiracy made? What's the evidence of the conspiracy? Not say the evidence, but the case shows primary facts, and there's a distinction, obviously. But it's quite clear that primary facts must be shown if it's a case of inference. And this, again, can only be a case of inference, because there's certainly nothing on the face of this pleading to suggest there's something primary about it. So Project Green was designed to assist, conspire with, aid and abet non-United States customers is an ultimate conclusion from which, in English eyes, there must be primary facts to support that conclusion, to tilt the balance in favour of that conclusion. And then the question of evasion of sanctions at the bottom. Again, individual words are allegations, but an individual allegation, for example, of evasion of sanctions includes the allegation that sanctions were breached. Well, that needs to be pleaded out in English eyes as a primary fact. But secondly, sanctions were deliberately breached to constitute the word evasion. So who deliberately breached them? What are the primary facts from which the inference of evasion is drawn? As opposed, for example, innocent breach. That's another, if there was a breach. It's more than simply an assertion. It's an assertion of serious wrongdoing for which the primary facts must be alleged. And this isn't necessarily a criticism of the Brutus pleading per se. It's just their form of pleading. It seems, all right, it got struck out, but I'm not sure it was struck out for pleading reasons, but it may well be that's what is done over there, but it's not what is done here, and therefore adoption of this can't work. Similarly, 44, jumping ahead of myself, if you go back to 24.2, there's then a reference to 42.42c. You see the allegation of 44c, the mandate of the committee was to develop strategies to evade the Iran sanctions. Well, what are the primary facts from which that is alleged?
Well, you missed out 42b.
No, I only missed that out because it's not referred to yet. It may come back. Does it come back? For some reason, I mean, we're happy to go to it, but I was just looking at the 24.2. But 42B is we submit the same issue. They've identified a client coverage group, which covered all SCB clients, but then says OCC in Dubai was deployed to create fraudulent records. That's equivalent to saying X is a fraudster. That's what that allegation is.
Well, it's a little bit more particularised than that, isn't it? Create fraudulent records that allowed Iranian clients to open accounts without their Iranian connection being detected. Very active trying to get new clients in Iran even after 2010. And we're talking about levels of abstraction here, aren't we?
Well, yeah. Lordship is right. We are talking to some extent at levels of abstraction, but nevertheless, one always must orientate herself in this case, which is this is an allegation by adoption of very serious, very widespread fraud across the piece. And, all right, you might say, well, fraud is fraud and everything needs to have a proper pleading, but clearly the more serious, the more realistic the obligations must be. And your Lordship is right, there are levels of abstraction, but deployed to create fraudulent records, even with that little description afterwards, is not, we submit, anywhere close to a set of primary facts supporting an allegation that a department of the bank was actually used for the purpose of fraud. And similarly, the rest of that sentence was active in trying to get new clients in Iran after 2010. That is very abstract, from which nothing can be drawn. And then there's a reference to winding down.
Take it again. Imagine that an English bank customer has a conversation with a former bank officer, and the bank officer says, look, I think you ought to know, I know this from while I was working there, but while I was there, customers like you were seriously defrauded by the bank. They had in operation a system whereby they deliberately, over a period of time, extracted monies of your account, from your account, which were not properly to be debited. Now, that is an utterly unparticularised, broad allegation of fraud, but it seems to me that being told that by a bank official would be credible evidence upon which you could plead that case. Now, you wouldn't be able to plead when it happened, where it happened, how it happened, but it seems to me you could say it happened.
Well,
I mean, you might have to demonstrate enough to show that you were a victim of this fraud, but it seems to me that you don't have to necessarily descend to the granular particulars of fraud in order to allege it.
well, what you do know on the test is you must allege sufficient primary facts from which the inference of fraud is more likely than not. That's the test that we're shooting at.
Yeah.
Now, there may or may not be an individual case where that is sufficient. And Your Lordship, I don't accept necessarily Your Lordship's example. You could plead that. That may be an example, for instance, for third-party disclosure or something like that, that might enable the claim to be pleaded. I'm not accepting that the claim could be pleaded in Your Lordship's example.
So a bank official who was working there tells the customer you were defrauded by the bank to the extent of, say, £1 million. You don't think that would justify a claim based upon that evidence? That the official who knows he was there tells you you were defrauded of £1 million. By that money was taken out of the bank.
Your Lordship's already describing...
Some difficulty striking that out.
Your Lordship's already describing, in the example, you descend into the sort of level of detail which amounts to the primary facts in support of the case. So,
Not a lot of detail.
not a lot of detail, but I mean, in contrast to this, in Your Lordship's example, the man says you were defrauded in the following amounts or whatever it is, then at least you've got some primary facts.
Well, in a large amount.
Well, the more abstract you get, the more you run into this problem.
But surely you'd be entitled to plead fraud based on that evidence, and then you get disclosure which would show you exactly what was taken when.
Well, it depends what you have been told and what you can plead. I think there are variations there. And the more abstract it is, the more it's simply detail-free, the more difficulty there is. But we're not even in that situation here because this is completely detail-free. This is simply conclusions or I say detail-free, the detail is so light compared to the serious conclusions drawn from it that we submit that these facts are not sufficient to tilt the balance in favour of fraud. And that's the test that we're looking
Well,
at.
it's certainly setting out a fairly high level, a fraud. But it says what the fraud was, who were the individuals who initiated it, which departments were involved, what they were doing in order to pursue this fraudulent course of conduct. The mechanisms which we use, the use of sundry accounts, etc.
Even the sundry account, similar thing. It's all very well to say the use of sundry accounts, but which are alleged to be part of a conspiracy. But that in and of itself doesn't show there was a conspiracy. And all these allegations being put, I mean, one has to put aside the project, in a sense, they've anchored themselves on Project Green, because there was a Project Green, so it's a slight diversion. That's a matter of fact, in a sense, is in the bag, if you like. But it's beyond that. Did that herald this widespread conspiracy? And we say that when looking at that question, what one sees here are there no facts or conclusory facts that everything was a fraud. Now, it is right that they've descended to some level of detail, say, well, there was a department, the use of summary accounts, but that material doesn't, we submit, tilt the balance in favour of dishonesty. It's always the point we must come back to. One has to ask, how would this be pleaded in England? It wouldn't be pleaded like this. We submit it couldn't be pleaded like this. It doesn't really, in respect, get any better, but even at the bottom of page 45, SCB Dubai played a central role in SCB's scheme to evade Iran sanctions. That's a rolled up plea of a number of conclusions with a purpose alleged, but nothing else attached to it. And then 40, I'm jumping ahead a little bit, but I know that if you go back to 24.3, there's then a reference to 43. So they use various means, egregious measures adopted to evade the sanctions of the OLT3 system. Now, of course, there was an OLT system, so that's not a fact that's going to be in dispute to anybody. But the allegation, the critical allegation here at the bottom of 43A, it was designed to have no ability to suspend or block a deal potentially violating the sanctions and create no record of illegal transaction. So it's an allegation of dishonest conduct in the design of a system. So they complete the system, but that's not pleading a fraud. The conclusion is it was designed for a fraudulent purpose, and that's where there are no primary facts.
Let's just suppose for a moment that that were true. What could they have pleaded?
Well, in a sense, that begs the question as to how a claimant such as this ought to approach an allegation such as this.
Well, suppose it is in fact the case that OLT3 was designed in this way. You say you can't simply assert that. You have to put forward primary facts justifying that. What would the primary facts be, supposing it to be true?
Well, without answering that question immediately, let's just ask, well, this allegation is made by Brutus. So is the assumption that they've got facts in support of it, or is this just their assertion? But that's, in a sense, a different point. The starting point is that one shouldn't bring a fraud claim unless there's material to bring it in the first place. If they don't have the material, they shouldn't bring it, number one. Secondly, there may well be material. I mean, there must be material. Well, I say there must be. In order for that allegation to be asserted properly, there must be some facts which support it. So the allegation that they were designed for a certain purpose would have to have, if it were properly alleged, some facts supporting the design. So, for example, there may be some individual who agreed with it, maybe a document that agrees with it. There may be some evidence of how it was designed.
So you can only allege it if you are in a position to provide evidential support.
Well,
beyond what you've been told by my Lord's whistleblower.
Lord, yes, because this is a fundamental basis on which one pleads fraud claims. You only plead a fraud claim if you have a fraud claim to plead.
But it's not good enough that you have been told that this is the case by somebody who appears to be reliable. In order merely to plead it, as aside from proving it, you have to be able to provide details of evidence, really.
Well, details of primary facts, yes.
What would the primary facts be beyond?
Well, the primary facts, leave aside the question whether these claimants could obtain these primary facts, that's a different question. The primary facts which would be required to support an allegation of fraudulent design of a system, for example, could be all sorts of primary facts. So there could be documentary evidence about how the system was created.
Is that a fact? That's evidence. What's the primary fact?
Well, we saw from the primary fact would be either things people did or documents which were created which implemented the fraudulent conduct. So there would be, at least in theory, the trouble I have with this is that it may well be there's nothing at all in support of this. It may well just be assertion.
But on your case, even if this is true, you can't plead it unless you can provide primary facts from which you can justify the pleading. So I'm just trying to understand what sort of primary facts it would be, which isn't evidence, because evidence you don't have to plead.
You don't have to plead the evidence. You have to plead, remembering the test is you have to plead the primary facts from which the inference, the dishonest inference is to be drawn.
I'm not sure it's a matter of inference at all.
Well, the dishonest inference here is that it was designed for a fraudulent purpose. That's an allegation of mental conduct inferred, presumably, from something. So the difficulty I have with all this is that it may well be this is just assertion from somebody rather than drawn from anything at all. But Your Lordship's question is, what if you were to plead this properly, could you do it? There could, in theory, if this were true, be documents which would, from which an inference of fraudulent design could properly be drawn. Or there could, in theory, be, I suppose, actual evidence of conduct from which the inference could be drawn. But in the fraud world...
Just on the documents, though, that's a bit unrealistic, isn't it? To think that the claimants would have the documents.
Well, yes, but in a sense that's...
And that's ultimately what these cases are always all about. Do they get struck out before disclosure, or is there another go after disclosure?
Well,
because claimants very often, it is an unlevel playing field, or can be an unlevel playing field. So isn't it a bit unrealistic to say, well, documents, I'm sure documents could show one way or the other, but the claimants are unlikely to have the documents.
Lord, yes, I agree with that, and I was just trying to answer the question, well, what could there be?
Yeah. And
there could be documents. In Your Lordship's question, of course, you're right, and that's why I took you to Mr. Justice Snowden's judgment. He talks about asymmetry of information and the possibly generous approach to pleadings at the outset. Nevertheless, that always has to be set against the rules about pleading fraud. And in a sense, some of the argument we've been having with respect is a little bit back to front. Because the argument ought not to be, well, assume this is true, how on earth could you plead it? The answer is there enough to plead it? Because if there isn't enough to plead it, you don't get to the disclosure point. It's simply just what the rules say. And that's why they have that test from Keckman. It has to be pleaded to support the inference. If you can get enough to support the inference, you can get to disclosure. But it's not an answer in a fraud claim respect to say, well, because I don't have the information, let me get to disclosure and I can fill the gaps. And we submit that this allegation, because it's piggybacking at best on allegations which aren't primary fact-based, it must fall foul of the rule. And arguments about what could they get and what couldn't they get, what it might be or what it might not be, are kind of beside the point we submit, because one has to ask what have they pleaded and what have they pleaded enough. And it may be, my Lord Justice Phillips' point, it may be all they have really pleaded is, well, this is what Brutus have said. And maybe that's their primary fact.
Can I just query whether it's right that you have to plead primary facts? I think what SOFA says is fraud or dishonesty must be specifically alleged and sufficiently particularized. It then says dishonesty can be inferred from primary facts, provided that those primary facts are themselves pleaded.
Yes.
So I think it is the case you have to plead the primary facts if you are seeking to infer fraud, dishonesty. But that's not the basic rule. The basic rule is that you must specifically allege the fraud, dishonesty and particularize it. That's a different thing.
Lord, it's not a different thing we submit in circumstances in which allegations such as this are by their nature, albeit not said so in terms, inferences. because these allegations of fraudulent design, fraudulent concealment, etc., are, we submit, inferential claims of dishonesty. So we are in this situation where, under SOFA and previous cases referred to, three verbals, etc., you can't simply allege something without alleging the primary facts on which the actual inference is sought to be drawn. Now, there may be some fraud cases, difficult to imagine, but there may be some fraud cases, possibly, where there is, I was trying to think of this before, and there's sort of hand in the tail evidence, for example. So you might say, that's not an inference. I've got the actual primary evidence of that, so I don't need to infer dishonesty. I've got I've got a video of the hand in the till. 99.9% of fraud cases, as your Lordship knows, will be inferential. Say, look at this material, I'm inferring this was a dishonest conduct attached to it. And that's what this is.
Well, but you can have the case when usually what you're seeking to infer is the mental element, or in conspiracy, the agreement.
Yes.
And that's what you need the primary facts to infer from.
Yes.
That there was a mens rea, or there was a combination. But if you are alleging that X and Y agreed to pursue an unlawful scheme whereby they would do the following and they did it, then you have pleaded the dishonesty and or the fraud or the conspiracy. The question may be whether or not it's sufficiently particularized, but you're not seeking to infer fraud, dishonesty, or combination from primary facts.
But in that example, if you like, the primary fact is the agreement itself, which you're alleging.
Yes.
And there may be circumstances in which there is an agreement can be alleged by primary fact. Most of the time, the agreement itself is an inference as well.
Yes.
So you are at levels of inference. You infer the agreement, and you infer a dishonest element to the agreement.
But this is a case where they are alleging a specific, clear-cut program, agreement, etc. I mean, this is saying clear terms. This isn't an inference. This was an actual, express, agreed program.
Well,
To do this.
I'd submit no. They haven't pleaded, for example, in Lordship's question, as it would be, it's very specific. On X date, such and such was agreed, and these are the terms of the agreement. Therefore, I don't need to infer.
It's saying it was initiated at SCB London headquarters, headed by and names the individual.
Yes, there's a course of conduct from which they're inferring a conspiracy, and from which they are inferring a dishonest conspiracy. So it's the course of conduct which they're alleging, and then they then seek to infer onto that dishonesty. So it's not, with respect to your Lordship's example of if you like, a simple primary agreement in which everything else follows. It's a set of conclusions from that.
They are alleging that, aren't they? They're saying that high-level SCB officials did deliberately operate this scheme. They haven't particularized it, saying exactly when the agreements were made, but they are saying it was an express agreement between high-level officials, and they've named two of them.
Well, they say they operated a program, known as Project Green, for example, run by Trade Finance, with deliberately excluding compliance officers. And we submit that on proper analysis is an inference of deliberate misconduct drawn from something. I don't know what it is drawn from, but that's where they get to. It's not alleging that there was a specific sat-down agreement to deliberately do something, which would be in the 1.1% of cases that this is inferential. The mere fact that they're alleging this and they don't use the words inference doesn't mean that on proper analysis that is exactly what they're not doing. What they are doing. And we submit that is what they are doing. They are, by definition or necessarily, inferring an agreement from the conduct they allege, and inferring a dishonest agreement from the conduct they allege. Otherwise, we submit it's impossible to read this pleading in any other way. And the answer, the reason why that's right, we submit, is clearly underlying all the fraud rules, quite apart from the importance of not pleading something that you can't plead, is the importance of ensuring that the defendant is able to deal with the case being put against it. Now, in your Lordship's example, I would say the 0.1% example, if there is actually an agreement written in terms, let's take it to an extreme situation, a conspiracy agreement, if you like, that you can plead, at least the defendant knows what the case is and can deal with that case. The difficult inferential case is you don't know what the case is unless you know what the primary facts are. Because you're not dealing with an agreement, you're dealing with something else. Here, what are the defendants dealing with? The defendants are facing this allegation. They're dealing with these vague, and we say inferential allegations of deliberate misconduct, deliberate deployance of fraudulent records, etc. And in the absence of a primary fact, we are in a situation where we submit the fraud rules are absolutely to the fore because there's no material, properly so called, from which these allegations can be addressed from the defendant's point of view. And that's why I think the difference is between a simple case and the normal case, which is inferential. And as soon as you get into the normal case of inferential, we submit they're a mile away from what's needed. And if that means they can't plead it, the answer is they can't plead it. I mean, there it is. The answer isn't, well, let's wait to disclose it to see what they can plead. And that's why we see the difficulty. The difficulty is that they have sought to adopt, if they have adopted, a pleading which isn't an English fraud pleading. And the advice ultimately is, if you can do it this way, then you can circumvent the English pleading rules by saying, well, I'll adopt someone else's pleading subject to different rules, and they'll still get by. And that's, we submit the ultimate advice of this. Now, just take it, we were looking at the, we jumped ahead a little bit, but we were looking at 24, and the only other, I think we've looked at 24.1, 2, and 3. 24.4. For
what it's worth, I think 24.3 identifies 43A to C, but I think the last bit must come from 43E. But I'm not sure that affects your general point.
Well, it's the same point across the piece.
Yes.
That these are conclusions. 24.4, just pausing there, because that may be seen to descend to primary facts, because it refers to actual transactions for whom the bank did business. So as opposed to what I would say are more conclusory allegations of fraud and dishonesty, here, on the face of it, possibly, at least in theory, they might be looking to transactions. The difficulty with that is when you see what's being put in the Brutus complaint, which is, let's see, page 48. You run into exactly the same problem, because there are a series of transactions beginning in 47 that are alleged to be transactions in breach of sanctions, remembering, of course, the issue about sanctions from the US government. And the allegation in 47, in January 2007, SCB performed an export finance transaction for Bank Tijarat. Such a transaction necessarily involved dollar clearing by SCB NY. Now, what primary facts are alleged there? On the face of it, certainly the first sentence, the fact that a transaction was performed, might be said to be a primary fact. The allegation that the transaction necessarily involved dollar clearing is an interpretation and seems to involve some legal analysis as well. But beyond that, that's all it says. So what you don't get in this pleading is an allegation of what sanction was breached by this transaction. You don't get in this pleading how this constitutes an evasion of sanctions. You don't get in this pleading how anybody was dishonest in relation to it. So whilst superficially we're into facts, we fall far short of the facts needed to plead the fraud claim. And then 24.5, go back to page 119, is not really related to the complaint, I think. You also have picked out that one of Brutus's points is they say they tipped off the US government in matters which led to the 2019 settlement, because one of their complaints is they'd like some of that, those monies as well. So this seems to be a complaint about that. The whistleblowers provided the US authorities with information needed to investigate the transaction involving Mr. Eliassi. He was connected to the 2019 settlement, also provided information to many other clients. They didn't investigate further. So it seems to be more related to that part of the Brutus complaint, certainly nothing in relation to the fraud allegation which is being alleged. And that is it. That is the evidential base for the pleaded allegation of dishonesty. And we submit the reasons I've sought to give. It doesn't satisfy the test. Can I just deal then with the judgment, which is at tab 5 of the appeal bundle. And we can pick it up at page 68, paragraph 55. Setting out some of these submissions, the judge says the important point about the amended defence, seems no problem pleading to it, no difficulty understanding it, no reservation of rights to strike out, and no request for further information. So the first set of points that the judge seems to have made in 55, we submit are irrelevant points to the submissions we were making before him. It's correct that the defence does plead to the Brutus allegations to the extent it was possible. The allegations were denied, but that contains no implicit acceptance that they're properly pleaded. And one can't draw any inference from that. Equally correct that there was no reservation in the pleading of a right to strike out, but that's not a right that needs to be reserved. In fact, on the evidence, the defence was served in February 22, and the defendant indicated it was considering a strikeout in June 22. So it wasn't in any event any particular period of time lapsing there. And it's also correct that the defendant didn't make a request for further information on these aspects. But the complaint, as I say, our complaint isn't that the valid claim is insufficiently particularized, but that it's simply fundamentally flawed, the reasons I've sought to explain, aligned with the fact that it's clear on the basis that what we've seen on the pleading and elsewhere that the claimants have no more particulars to give anyway. So those factors we say are sort of extraneous factors around the issue rather than dealing with the issue itself. And equally, at paragraph 57, the judge refers to the agreed case memorandum, which he appears to have given some importance. And the relevant bit of the agreed memorandum, which he sets out in 57, is the claimants allege that the 2019 settlements and the Brutus complaint evidence relevant misconduct on the part of the bank. And he sees that as an acceptance that the claim, including the Brutus allegations, were properly particularized. And we say that...
It is odd that a pleading doesn't say, although it's pleaded without prejudice to the defendant's contention, that paragraphs X to Y do not disclose an arguable case in forward.
Well,
not sure why that wasn't done.
Lord, sometimes these things are said, it's kind of argumentative in the pleading, you might say. It wasn't done per se, it doesn't need to be reserved. And as I say, we did notify the claimants by June 22 in relation to the DRD. So it wasn't a sort of secret, if you like, and it wasn't a change of mind as the judge seems to think either. But your lordship's right, we didn't say it on the pleading in terms, but it doesn't, we submit, address.
Well, even when you address the points in the pleading, you don't make the point there that what's said is not argued.
Lord, your lordship's right, but say one can take different views about this. But and one sees very often an aggressive defence that says this is all without prejudice to application to strike out, which never sees the light of day. It's just said as a matter of rhetoric. So your lordship's right, but it's not actually a pleading of material facts. It's a sort of argument that one puts in the document. Well, equally, the case memorandum, you see what the case memorandum says. The judge does appear to have attracted significance to it. As you'll see in 57, we submit there's no significance that could be attached to it. First of all it does, the passage he cited, is record what the claimants allege. So it's not an acceptance of the pleading or anything like it. Secondly, by the time of the case memorandum, the application to strike out had already been made, and indeed it's even referred to in the end part of the case memorandum. If you go to the supplemental bundle, tab 20, page 257. That's the wrong reference. Sorry. You go to the 314, or 24, tab 24, 314, the case memorandum. Sorry, I had the wrong reference, Lord. It's the case memorandum is at tab 24.
I'm not sure it is in my bundle. I see it's tab 25.
314.
Begins in 312.
I don't know why, but my bundle seems to be different. Because, did you say 312?
312 is the beginning of the case memorandum.
312, what I have is the second page of the application notice.
That is
Don't know why there's a difference.
unfortunate. Is it stamped 312?
At the bottom, it's stamped 312, and it's the second page of the application notice. I don't know why there's a difference. I mean, I don't think it matters because I can find the case memorandum at tab 25, page 377.
Okay. Are all the lordships the same?
No. For once, I have the right document. we should adjourn early to celebrate. 314, paragraph 9.
314, paragraph 9 is the paragraph thought to be of relevance to this. It's simply a record of what the claimants allege. 312, if your lordship forgive me, I'll go back, I'll use those numbers for the moment. Sets out at the beginning of the case memorandum was prepared for case management purposes only, not intended to alter the parties' cases. And 320, which is the end document of the tab, records in the procedural history of the case memorandum towards the bottom of the page that an application to strike out had been made.
Sorry, just so I'm clear, that's paragraph 20.4.
20, no, there's a procedural, does your lordship have a brief procedural history at the end of the case memorandum?
What I've got is I'm not sure. I've probably been what if I've got something set with agreed in square brackets case memorandum.
Yes.
And then the very last page is I see, yes, that's the page 385 with a series of boxes.
A series of boxes, yes. And towards the end it records that the application to strike out had been made. So we submit you can't infer from what is said in the case memorandum, first of all, on the basis of what is said, but secondly, in the context in which it's said, that there's some acceptance of the pleading. Also in circumstances in which it's clear from the commercial court guide, you wouldn't have to turn it up, the case memorandum is simply a simple procedural document intended to help the judge. It's not a battleground, and it shouldn't become a battleground. So insofar as the judge placed some reliance on the case memorandum, we submit it was inappropriate. And you can see that he did place reliance, because when you get to 58 of the judgment, on page, I hope 68, he says that there's been a rethink of the position, which wasn't the case, decided to pursue this application insofar as it's based on inadequate pleading of the particulars or primary facts. I find it difficult to see how that can probably be suggested at this stage. So it appears the judge sought some form of procedural preclusion by reason of those documents, either the defence document or the case memorandum, which we submit, again, is not a relevant factor.
It is right, though, isn't it, that there was a delay of 18 months,
Yes.
not quite, nearly, between the defence and the application to strike out the particulars of claim.
Well, yes. I mean,
in the Technology and Construction Court, obviously, we do our trials within 18 months, so it would have been quite late to apply to strike out. I appreciate this is a bigger case, so it might have taken a bit longer. But it's quite a long time in litigation terms not to apply to strike out a pleading that you say is fundamentally defective.
Your Lordship is right, and I don't want to bore everyone with the grisly history of this case, but it has proceeded very slowly, even now, we don't know exactly who the claimants are or their funds are. That needs to be resolved in terms of names. What happened in this case, there are 4 claim forms issued at different points in time with different claimants popping in and out of them. It has proceeded at a very slow pace, and one of the reasons for various the applications was to try to get the claimants to do work which they had not otherwise done. It was the defendant who booked, that's the right term, the case management conference, because it hadn't been done at all, and there was a 3-day listing in it, and we got the date we did. The application was made, if you like, in good time before the CMC, because that would be appropriate time to hear it. Your Lordship is right, it could have been done earlier, but this case is, I think, unusual, and not necessarily the defendant's fault, by the way, about how slow it's gone through. Your Lordship is right, as a matter of objective reality, we could have done it earlier, but this was a very slow case for other reasons. But as I said earlier, we did notify the claimants, at least of our considering the point, in June 22, so it wasn't news to them. And going back to the judgment, we looked at 58, there's then 59, where the judge discusses the question of verification of the pleading and addresses my point about conclusory allegations and reaches a conclusion that it's adequately particularized. The only further question is whether there's available evidence to fraud and dishonesty. But for the reasons I sought to submit earlier, what the judge didn't consider in terms was whether there were primary facts to support the allegations being made. He then deals, paragraph 60, with the statement of truth, which again doesn't really touch on the issue that we are concerned with. And 61, Mr. Shrimpton's evidence, which again doesn't touch on the issue we're concerned with.
So on this thesis, the key bit is in paragraph 59, where the judge says, it seems to me that this has been adequately particularized.
Well, maybe it's 2 parts, Lord. I mean, leaving us, there are certain things which we submit he took into account which weren't relevant on the pleadings issue. I think there are 2 points. 58, he appears to have taken the view that because, as he thought, there was a rethink of the position, which wasn't the case, therefore he couldn't see that the primary facts point could be properly suggested. So he seems to have suggested with some sort of preclusion of some sort against that. And we say that doesn't get me home as such, but in terms of the judge's reason, that was wrong. 59 is probably the meat of it. But having said that the primary facts point essentially doesn't come into play, as he appears to say in 58, he then says, with respect to any real analysis, that's adequately particularized. So he didn't deal with my first point, which was you can't just piggyback on someone else's claim. He didn't deal with my second point, which is, have they pleaded the primary facts to support the inferences that are alleged? It looks as if he didn't directly address either question. Can I move on, Lordships, to Maxpower? Different sort of, ultimately we end up in the same place, but a different sort of analysis. Can we begin by going to the particulars of claim, page 120, tab 7, page 120. And it begins, the Maxpower story begins in paragraph 28 with an explanation of how the story broke in an article on the 26th of April 2016 about an allegation of bribery. That's in paragraph 28. And in paragraph 29, the claimants aver, you'll see going over the page in 121, paragraph 29.2, they aver that there was a corrupt scheme to bribe Indonesian government officials. That's what they call the bribery scheme, and it's an averral that there was such a scheme. The bribery scheme is said to be relevant for some of the allegations of falsity and misleading statements. So if you go to page 123, 32.10 and 32.11 are what they call bribery compliance representations, bribery compliance knowledge representations. So as I said earlier, these are the implied representations in the statements, and there are said to be relevant statements relating to bribery. And then there's PDMR knowledge, or knowledge as alleged. If you go to paragraph 73, sorry, we begin on page 70, which is page 135. And to be clear where I'm going, the basis to strike out this part of the claim is not the same as the Brutus part of the claim. It's essentially focused on the knowledge allegations. So paragraph 70 identifies what are called senior management of SC PLC. And that's not a relevant term for PDMRs, but it's a narratively relevant term. And there are various categories of person said to be senior management. And 70.1 refers to de jure directors of SC PLC. And then it said in various settlements, the executive directors are referred to as group executives. 70.2, a group management committee, including executives and other executives. And 70.3, de jure directors of the bank. So that's a group of people who ultimately, as we'll see, are called by the claimants the group executive. If you then go to 75, paragraph 75, there are two paragraphs which plead dishonest knowledge on part of group executive, which you'll find on page 146. These are the sole paragraphs pleaded in support of the allegation of dishonesty in relation to the Maxpower scheme. And you'll see 75.1 refers to the article, the MLEX article referred to earlier, which reports an allegation and says that the defendant is aware of the alleged wrongdoing. And the pleading is, it is to be inferred that this refers to the awareness of SC PLC's group executive. 75.2, there's then a composite set of allegations about investigations into the bribery scheme being conducted following a whistleblower by Sidley Alston, King and Spalding, and PwC. And it's then said that some Maxpower founders had their contracts terminated, and it's to be inferred that such steps would not have taken place without knowledge of SC PLC's group executive. So those are the two knowledge allegations in support of what needs to be and is an allegation of dishonesty. Because when you then go on to 147, um, 77 and 78 comprise the allegations of guilty knowledge, dishonesty, and dishonest delay in respect of relevant misconduct and also in respect of the Maxpower scheme. So based on the knowledge allegation in 75, we just looked at, there's an allegation that PDMRs were dishonest, 77 and 78. If you then turn in this same bundle to tab 9, page 300.
Page?
300. This is the reply, and this is a response to certain pleas in the defence that the constitution of the group executive wasn't clear, and that employees weren't involved in day-to-day operations. And there are various allegations in paragraph 24 in the reply, mainly relating to, Lordships may have picked up what we call the Maxpower directors. There were 4 SC employees, SC group employees, who were directors of Maxpower. And there was an allegation previously that they were PDMRs of SC. That has been struck out by the judge. So they are the people being referred to largely in 24 as Maxpower directors. You will see in 24.4, just to seeing the target that the claimants seem to think they're hitting. At 24.3, one of the denials is that the claimant's allegation that senior individuals at the bank were informed of the allegations of bribery is inadequately pleaded. It seems to be that they are focusing on an allegation of knowledge of the allegations of bribery. And similarly, 24.5, on page 303 to 304, another allegation response, 24.5, right at the bottom, that SCPE, that's the private equity debt, it's been inferred over the page that SCPE knew about the bribery allegations from at least March 2015. So it looks as if from the pleading that is the target they thought they were hitting. Still in the reply, if you go to 313, paragraph 36.2 explains that the group executive, i.e. the ones who are alleged to have had the knowledge, is a reference to the persons described at paragraph 70.1, 70.2, and 70.3 of the particulars of claim which we just looked at. So that's de jure directors of SC, group management board members, and de jure directors of SC Bank. As we've indicated on our scale, there are about 50 of them across the various pieces. One point my friend takes in his skeleton, just to try to clear it off, because apparently thought to be of significance. It's paragraph 34 of the skeleton, don't need to turn it up. It's said to be a false premise, or the defendant's proceeding on a false premise that the claimant's allegation is that all members of the group executive had the relevant knowledge. Whereas it's said that the allegation is that one or more members of the group executive had the relevant knowledge. For the purpose of the application to strike out, we submit that's a distinction without a difference because the application is the same, but the problems are the same, whether the allegation is all 50 or up to 50, which is their formulation. But for what it's worth, and again, just going back to the pleading, we submit wrong as a matter of pleading. If you go back to page 146, paragraph 75 we just looked at, the allegation is, for example, 75.1. This refers to the awareness of the group executive. Bear in mind, the group executive isn't a real body. It doesn't actually, there's no formal body called the group executive. The group executive is a description by the claimants of those people who fall within the three categories that we just looked at. So we submit as a matter of pleading, what they've actually pleaded is, for what it's worth, and we say it's not worth anything, but just to try to deal with it, they've actually pleaded that was an awareness of those persons who they characterize as being within the group executive. What they have then said, just to be clear about it, if you go to 147, 76, they say that the relevant misconduct, bribery scheme, and untrue and misleading statements were at all material times all or each known to at least one PDMR. So that's where the at least one language comes in. What the pleading actually says, to be clear about this, is that all members of the group executive knew, and one of them at least was a PDMR. That's the proper interpretation of what they plead. I say we submit none of that really matters to the purpose of the argument, but to be clear what the pleading actually is, on its face, we submit is all 50, even though not necessarily all 50 are PDMRs. So the basis of the strikeout and the appeal is we submit there's no or no adequate case of PDMR knowledge sufficient to support the Section 98 claim. And there are three grounds of appeal we've put in. I can maybe deal with the first one before shorter Germans, subject to lordships, is what we call the G4S point. It's slightly technical, let's say technical, again a pleading point, nonetheless for that, important. The G4S point is this: it engages the question of what the claimants actually pleaded in this case. What Mr. Justice Miles said in the G4S case, as I said earlier, was that a PDMR must be alleged to be a de jure director or a de facto director or possibly a shadow director. And plainly, if such an allegation is made, there must be a basis to make it. And that was the basis on which the judge in our case struck out the claim against the four Maxpower directors, because there was no actual allegation any of them was a de facto or de jure director. The same point also applies, however, to those members of the group executive who are not de jure directors of SC. There is a list somewhere, I think there are about 22 or maybe 32 de jure directors of SC who are members of the alleged group executive, and about 20 who aren't. But we say the same point, the G4S point, if you like, applies to those members of the group executive who are not de jure, because there's no allegation in the pleadings, no supported allegation, that those persons were either de jure or de facto directors of SC. Turning back to trying to make that good on the pleadings in the minutes I have, if you go back to 135, so it begins, I'll try to cover everything that's said, and maybe that's enough. 70 is the starting point that we just looked at. That describes those people who they subsequently say are part of the group executive. And other than the de jure board referred to, there's no allegation here that any of the group executive are de jure or are de facto directors of SC plc. So that doesn't include any such allegation in paragraph 70. And 75, the allegation of knowledge we've looked at doesn't include any allegation of de facto or de jure director. And similarly, 76, which we also looked at, refers to PDMRs, but doesn't include an allegation of de facto or de jure director. So far on the particulars of claim, there's no allegation that anybody in the group executive who wasn't a de jure director of SC plc was either a was a de facto director of SC plc. Therefore, no allegation could be made those persons were PDMRs. If we can turn, please, to the supplemental bundle. I know we have the page numbering difficulty. And for some of you, I hope it's tab 19, page 254. Lord, it's the claimant's responses to the defendant's request for further information. There are two sets. It's the first set.
And this is under paragraph 70, 72, and 74.
Yes. It's page 254.
In my version, 263. I don't know why.
So we asked them the specific question, as you'll see under paragraph 70, etc., as to whether the following categories of individuals were PDMRs, even if they were not de jure directors, and if so, the basis on which it's alleged. And the answer was, we allege that members of the Group Management Committee and de jure directors are likely to fulfill the definition of PDMR by virtue of those roles. Others may also fulfill that definition. And then 20 says it's legal submission in the case of de jure directors of the bank and members of the Group Management Committee, the roles were functionally the same. So we asked them specifically the question, and that's the answer we got, that they were likely to do it rather than they, in fact, did. And if you then go, please, tab 28, which is page 339, which is the second request for information.
Yeah, I mean, that's certainly. I think that's tab 21 in mine. I have no idea why.
Well, probably not inappropriate, but would you like us to reconfigure your bundle over
No.
lunchtime? I can see it might.
Not unless it's going to turn out that I'm missing something or.
Sounds like we can get by. 28, second request for further information, and the request this time on page 340 was about paragraph 72, the relevant misconduct. It wasn't about Maxpower at all. It was about all the other stuff. And we asked them who were the PDMRs for that purpose. And the answer given at 341 and 342 is 12 people, as you'll see in 342, the 12 individuals identified. So in contrast to the position of the group executive in relation to Maxpower, when we got onto the 2019 settlement stuff, we asked them who are your PDMRs here, and they identified 12 people. And for each of those 12, what they then plead from, ignore the red stuff at the moment, what they then plead after that are specific allegations. So 2.1 page 343, Mr. Medding's the de jure director. 2.3, Mr. Shankar was also a de facto director, and then other matters pleaded in relation to support of that. Then over the page 2.4, Mr. Shankar, de facto director, Mr. Wish, de facto director, Mr. Miller, and so forth. So for each of that aspect of the case, they identify those people they say were PDMRs, and they make the allegation they were de facto directors, and they support that allegation with the facts they put. Well, I think that I haven't quite finished this point, but maybe the right point to
2 o'clock then.